Good day, everyone. Eric Olsen from Helps, uh, law firm for seniors and disabled persons. Welcome to our YouTube channel. Please tell me if you can hear me. I'm glad to have you here. Sorry for I'm a minute late. Um, Good. Okay. So my name's Eric. I've been an attorney for 46 years, the founder of Helps. Helps is a national law firm that represents seniors and disabled persons who owe debt they can't afford to pay. Our main mission is to protect seniors from collector harassment. Our second mission is to educate seniors how they can maintain their financial independence. We do these YouTube live videos every Monday through Thursday, and I'm glad to have you here. The topic I want to talk about for a second is, should I worry about a judgment? Okay, and if you've been listening to me before, and you're a senior or on disability, you've probably heard me say many times that you probably don't need to worry about a judgment, and I'm going to explain to you why. Okay, and we're going to start off with this. If you have any questions, you can put them in your chat feature. So first off, what is a judgment? Okay, well, there's all kinds of judgments, but the judgments we're talking about is a judgment for debt, that you might owe a debt. Okay, so like a credit card. If you owe a credit card and you don't pay it, there's a possibility uh, that a credit card company could choose to sue you to establish that you owe the money. And when that happens, at the end, if a judge signs something saying that you owe the money, then that is called a judgment. And for a lot of seniors, that's meaningless, and I'll explain why. Okay, but first let's talk about a judgment. So how does a judgment come to pass? First off, you have to owe a debt, okay, or someone has to say that you owe a debt, okay. They're going to probably make some demands on you to pay it. If you don't pay it, they have several choices. They might just forget about it. They might send it to a new debt collector. That new debt collector may call you or harass you or send you demand letters. They may give up and send it to a new debt collector. Who knows? All on the process, someone may decide to file a lawsuit. Now, why do they make that decision? Don't know exactly. They figure that if they sue you, that if they get a judgment, they might be able to try to collect from you. They might be able to garnish a bank account. Usually, is about the only way they do that. But a lot of it is they're trying to scare you into thinking something's bad going to happen, so that you're going to call them to make arrangements to pay a debt. Okay. Now, so a judgment is a court order from a judge saying you owe the debt. Now, just because you say that you owe the debt doesn't mean you have to pay the debt, because there are state laws and federal laws that protect income and assets from a creditor. So for a lot of seniors, they are what's called judgment proof, which means even though it's a judgment, no one can get anything from them. They're judgment proof. Okay? Now, normally when you're sued, they'll serve some papers on you. Someone will knock on the door and hand you some papers. Now, it can come in different ways. In some states, if it's a small, they might be able to send it by certified mail, but 95% of the time, someone actually hands you paperwork. Okay? There are some consequences of the judgment. I'll talk about those in a second. Um, but usually those aren't serious. So in some states, a lawsuit is not called a judgment. In fact, I talked to someone yesterday from Virginia. In Virginia, they have what's called a warrant in debt. If you get sued, you don't get a summons and complaint like it is in the rest of the country. You get a warrant in debt, okay, which is kind of like it's an old term from the 1800s that lets people, it's like a judgment. But the problem with that term is that it can scare someone. I may have mentioned this yesterday. You normally think of a warrant as being a warrant for your arrest. Well, that's not what a warrant in debt is. It's just a regular summons and complaint to sue you to get money. Okay, and that's in Virginia. Um, so someone had asked, well, what is a default? What about a default judgment? Well, okay, A judgment is a judgment is a there's different types of judgment. Okay, a default judgment is a type of judgment when someone has sued you and you haven't answered or contested the lawsuit, and they win by default. Okay, you just kind of give up. Okay, and most of the seniors that we talk to, they have default judgments. They owe the money. Okay, now if you want to contest it, you can contest it. You normally would have to file an answer, and where you would give reasons why you don't owe the money. And it is possible to represent yourself. Most of our clients, they don't want to do that. They owe the money and they don't want to contest the lawsuit. But you can always contest it if you want. There's websites that tell you how to do that if you want to, but most of our clients don't worry about that. And for good reason. Because if you're judgment proof, if they can't get anything from you, then you don't need to worry about a lawsuit for debt or a judgment. Okay? So a judgment is simply an order by the court saying that you owe money. Now, as far as enforcing the judgment, a judge really doesn't have a lot to do with that. That's up to the attorney who sued you. Then they have some options. If they happen to know where you bank, they could file what's called a writ of garnishment against your bank account. Okay, and normally that's not a problem for a senior. I'll explain why real quick. Um, there's a federal rule that came into effect in 2012 that tells banks and credit unions that if they get a writ of garnishment, if someone gets a judgment against you and they happen to garnish your bank accounts, that's an order that says an attorney can submit that order. Okay, it doesn't have to be a judge. An attorney does it, telling the bank to pay money because I got this judgment. Well, the bank has 48 hours to look at your bank account, and if money came from a federal source such as Social Security in your bank account, they're told that they have to times the monthly amount times two and automatically protect that sum from garnishment. So if you got 1,500 in Social Security each month, 3,000 is protected automatically, even if money in the account came from another source. Now, if you got Social Security of 1,500 and 500 in VA benefits, that's another federal source of funds. That's 2,000 times two would be 4,000. So, uh, so your bank account is protected automatically by your bank. Now, just because they have 48 hours to examine your account doesn't mean your account's going to be held up for 48 hours. This rule's been in effect since 2012, and the banks usually do it within 4 to 8 minutes. They do it pretty quick. Okay, so you don't need to worry about your money being held up. But it is important that if you are sued and you are a senior, that maybe you would consider just having one bank account, and that'd be the account to which your Social Security is deposited. Now, if you're going to have another account, you want to keep it to an absolute minimal. Now, if you had more than that other account, then that other account could be held up, and you'd have to file what's called a challenge of garnishment or claim of exemption, file some paperwork with the court, and the judge would order that money be released. Occasionally that happens with helps clients. We help them do that, or sometimes the client will prepare the form. We'll contact the other attorney, say, here, this money in this savings account was from a Social Security, it's protected. This is what they're filing with the court. Will you go ahead and release the money now without them having to go in front of the judge or to have it released? And the attorney almost always says, yeah, we'll go ahead and do that. So that's what a judgment is. It's an order by the court that you're supposed to pay money. Now, can they do other things? Well, under certain state laws, if they get a judgment, they're allowed to maybe ask some questions. For example, in Florida, they have what's called a fact information sheet that they send out pretty much automatically that has a series of about maybe 15 or 20 questions. Some of them, you wonder why those are questions. You fill that out and send it back. But there's nothing, and we help people do that. There's nothing in there that's going to hurt you, okay, if your income is Social Security or a pension. Remember, that money is protected. But that form you get, that fact information sheet, doesn't tell you, if you're a senior, that your income's protected. So it's all designed to try to scare or intimidate you into contacting the attorney who sued you and got the judgment to make arrangements to make payments. Okay? And different states have different forms that they use to try to scare, intimidate people into making payments. But the bottom line is, if you're a senior, you're receiving protected income, your income's protected, you don't need to worry about a judgment. The whole purpose, the one of the main purposes of helps is, if one of our clients gets sued, um, we ask you to get us a copy of the lawsuit just for 3 or 4 pages. Then we're going to send uh, a letter to the attorney who sued you, let him know that your income is protected, and that should let them know that the lawsuit really is a waste of their time. And then we're going to call you, explain why you don't need to go to court. And we'll send you some emails explaining how your assets are protected. And if you get any follow-up paperwork, you can get that to helps, and we'll help you with that. Okay, we don't represent people in court. We don't contest people in lawsuits, but we give you legal information so you don't need to worry. Okay, so for these reasons, uh, a judgment is kind of meaningless. So for the vast majority of seniors, okay, um, are they going to try to take anything other than garnishing your bank account? Well, different states have exemption laws that protect a certain amount of equity in a home, a certain amount of equity in household goods, um, furniture, tools of trade, a whole list. A lot of states have what's called a wild card exemption, which means, if it isn't listed in our exemption list, if you have equity of like, 5,000, you, you can protect 5,000 in any other property that you have. Now, there'll be an exemption on your car, but to be frank about it, it's not the practice of consumer judgment creditors like credit card companies to ever try to go after your other property, even if you happen to have equity in that property over and above the state exemption. They don't do that for a number of reasons. Number one reason, it's complicated. Number two reason, you might own it with someone else that makes it even more complicated. So they don't. It's not their practice to do that. So you're not going to need to worry about them taking your other property. Even if you had a car that was worth free and clear, maybe the state exemption was 5,000, but the car's worth 10,000. No, they're not going to come after your car. Now, it's theoretically possible, but they just don't do it. Why do I know? Because I'm 74, been an attorney for 46 years, helps for the last 15 years, 13 years, okay, and filed between 30 and 40,000 bankruptcies. They're not going to go after your personal property like that, okay? Now, some you read on the internet, or some attorneys might scare you into thinking that's a possibility. But whenever we talk about things, we always have to talk about the odds, and sometimes these odds are so close to zero that they're not worth talking about. Okay, it's like there's some clouds outside. You shouldn't go outside because you could get hit by a bolt of lightning. Well, we don't live our lives that way. Okay, so don't worry. Okay, so I'm going to try to get your questions here. Um, Farmhouse asks, if they lien your house, would that lien impact your homeowner's insurance? No. The only way your homeowner insurance could be impacted is maybe by your credit rating, but that's not for all states, but for some states that's the case. However, Helps has a program called 7 Steps to a 720 Credit Score, where you can rebuild your credit. After you've been part of Helps for 90 days, you can rebuild your credit. It takes about a year and a half, 2 years to get your credit score up to over 700. But you can get your credit score built back up. Uh, Credit reports no longer show judgments or lawsuits on them anymore. It just shows information that's reported from a creditor. Um, okay, so Mrs. H asked, I got a letter sent to me via FedEx, and I think it was supposed to intimidate me by how it was sent. Do I need to be concerned if I get served by the courts? Um, you're probably right. Um, creditors will use all kinds of techniques to scare you to pick up the phone to call and make arrangements. And if you got a letter from FedEx from an attorney saying, you better call us or we're going to do something bad to you, which they can't do, but they can scare you into thinking that's going to happen. They might invest the $10 it costs to send that FedEx letter. Their their calculations show that if they do that, they increase the odds of someone calling them and make arrangements to make payments. Now remember, see, you're a senior. You're not like a younger person that has a job, okay, where they could garnish the wages. Okay, you're not there. Okay. Now, even if you are a senior and you are working, they're probably not going to be able to take any of your wages, and I'll explain why. One, they have to have a judgment, uh, which they may never even try to get. Number two, they'd have to know where you work, and that's not easy to know. There's no automatic place you can find out where someone's working. And then you have to make over a certain amount of money. And some states don't even permit garnishments of wages. There's a federal law that protects a minimum of 217.50 net per week in wages in every state. But some states protect more than that and don't even allow wages to be garnished. For example, in California, you can make like $600 a week free from garnishment. New York, it varies on the county where you live, but it just depends on the state. But at the very minimum, 217.50 net is protected per week. Now that's what you received after taxes and appropriate withholdings are taken out. So I don't want to discourage you from working or thinking that if you are sued that they're going to garnish your wages. We just don't run into it that often. And if it was a problem, we'll talk to you about what your options are. Okay? Do I need to be get concerned if I get served by the court? Not for the reasons that I've been talking about. You know, I tell people, I mean, you could get served by 100 different lawsuits and owe $100 million. If you're a senior getting Social Security, it doesn't matter. You're not going to have to pay it. Okay? I've experienced summons taped on my front door or in regular mail in my mailbox. It depends on the state. They allow you to serve in certain ways. You got to realize the person who's serving the summons, there's different persons that do that. It could be a civil deputy that works for the sheriff's department. Okay? Most counties, there's a sheriff in the county sheriff's office who's designated to be a civil deputy and he serves papers. He's not a criminal attorney. So if you had a sheriff come up and give you some paperwork, that doesn't mean it's a crime. No, it's just that's his job. But most of the time, a summons or a complaint would be served by a private party, maybe a company that's what they do, and they get paid if they successfully serve you. Okay, you don't have to make it easy on them. I've told the story about a lady that lived on a private driveway, and they had a gate that was locked in front of her private driveway, and the guy was trying to serve her, and I said, you don't need to make it easy on him. You don't need to open the gate. You don't need to go out there to pick it up. You don't need to call him back. Okay? I mean, you can if you want, but you don't need to. Okay? Will they be watching your bank account continually? No. When I first started practice, you know, um, you could call a bank and you could ask the bank, I have a check for $150 from John Doe. Will that check clear? And the bank would tell you yes or no. And then if you were a debt collector, you'd know whether you could file a writ of garnishment on the bank and get that money then. Right now, banks they will not talk to you. They won't give you one word about, even if they have a bank account for someone. Okay, they won't do that. Okay, so there's no really way for them to monitor your bank account, MCAT. They can't do it. So Ava asked, how do I stop the phone calls all day? Well, you're listening to the right channel. Okay, this is help eliminate legal problems for seniors. People that find out about helps, we help people in all 50 states. You call us, we talk to you about your situation. There's a federal law passed in 1978, the year I graduated from law school. Seems like yesterday, but it was a long time ago. That one of the provisions of that law, it's called the Fair Debt Collection Practices Act, is that if you're represented by an attorney, debt collectors can no longer call or send demand letters to you anymore. So people that enroll in helps, uh, they give us the creditors to whom they owe money or the debt collectors, and then we send out what's called a cease and desist letter. Uh, After you enroll, we try to do that within 24 to 48 hours, and then it's got to get to the creditor. They got to process it, and within 2 to 4 weeks. The communication from the debt collectors is going to stop. Now, in the meantime, if you got a call from a debt collector, you would just tell them, I'm represented by Helps. You give them their name and number, and tell them not to call you anymore, and you hang up the phone. They call us on the phone. We're going to tell them we represent you. You're getting Social Security. You can't pay the debt. Please leave them alone, and they will leave you alone. Okay? So that's how you're going to get them to stop. Except if your son said he uses a butterfly net to stop the calls. Um, I've been sued and got a judgment with a court date, but helps came through to me and the judge canceled the hearing. Well, I don't know if the judge canceled. Maybe the attorney on the other side, they called the court and said, it's a waste of time, cancel the hearing. The judge is really just a rubber stamp. Okay? He just, that's pretty much what he does on these kind of cases, unless there's a trial. Okay? Which there normally isn't. So yeah, so yeah, if Kat says she likes my shirt, but if you have another Citibank, if you yeah, if you have an account and you're a helps client, you can always give that to us. And so in other words, if you get a new collection notice from a new debt collector, you get that to us. When people enroll at helps, it's not a one-time thing. You're literally our client forever. So if you get a new collection notice from a new debt collector, you get it to us. We send them a letter so they leave you alone. Okay, we don't want you to worry. Okay, so I've got some notes here that clients have written in, this first one is from Alaska, and they give my name is so and so. I just have a few questions to ask you before deciding to go with Helps Law Group. I'm in her latter 70s, a woman, and her only income is $900 in Social Security. Uh, my husband is soon to be, he's younger, and wants to try to wait to collect his Social Security until he is 70 years old. In the meantime, he is self-employed as a locksmith in our city, and I know exactly where she lives. It is only part-time, and our last income tax return only shows our adjusted gross income as being around $20,000 a year. We have separate business bank accounts as well as our regular account. What money he might make goes into the business account first and is then transferred to our regular account where my Social Security is deposited. This is a good one. Okay, we have about almost 50,000 in credit card debt. But since the beginning of this year, his income has dropped significantly, and we are only able to try to keep up with the utilities, insurance, a truck payment, food, gas, etc., basic needs. How does it work with your bank account if my Social Security and his income is put into the same account to pay our necessary bills? Well, I'll answer that right now. If someone first has to sue you and get a judgment, and like I said earlier, if if they garnish the bank account, they examine the account, and if federal funds went into there, as long as the balance in the account was less than twice the amount of your federal funds you get each month, and she gets 900 times 2 would be $1,800, it's protected, even if the money in there came from his job, from work he did as a locksmith. So you just need to keep it less than twice the amount. Okay? Um, can creditors still touch that income? No. Keep it less than twice the amount. What would you suggest we do? Keep it less than twice the amount. I've looked into bankruptcy, and that is way out of our affordable option. That's right. The vast majority of seniors don't need to file bankruptcy. They can't afford to file bankruptcy. I did between 30 and 40,000 bankruptcies before I started Helps in 2012. I just saw the writing on the wall. Seniors would come in. I tell them you don't need to file bankruptcy, but when home creditors going to call. So what Helps does is we represent you as your attorney, so creditors have to leave you alone. And the way Helps works is we represent you ongoing. It's not one time. It's literally forever. So you don't have to deal with collectors. So she goes on to say, I was given a cost of $3,500 for an attorney fees and then $330 in court costs to file. We have no savings account. Only assets are my 10-year-old car, which is protected. You don't need to worry about it. Even if it was a brand new car, no creditor's going to come after your car. Okay. And a home that has a reverse mortgage on it. Okay. Any advice would be appreciated. I'm wanting to go with your law firm, but just want to know all the information before deciding. So we're going to call them back. We're going to tell them this, like I'm telling you now. If you're in that position and you have debt you can't afford to pay, you don't need to worry. And if you don't want to have to deal with the creditors calling you on the phone, if you're worried about getting sued and you don't know what to do, give Helps a call. We don't turn anyone away that qualifies for our service. Okay. Maybe 1 out of 5 or 6 of our clients get our help for free. Those that pay a very minimal amount. Okay. We don't want you to worry. So Monica asked, there was no trial, the judgment filed before I got the information to helps. Even if you got the information to helps, they would eventually get a judgment, Monica, but I'm not sure what next step would be. There really is no next step. Um, your judgment proof, they can't collect from you. Now, they may send you some paperwork asking some questions. It depends on the state where you live. And if that happened, you'd get that to helps and we'd tell you how to deal with it. Okay. So you're not going to need to worry at all. And if you worry, what do? You call helps, no matter how often. Uh, we want you to worry. L. Franklin says, I'm a helps client. I went to my Chase account that has a credit card that it defaulted on. Also, a car loan I'm current with. The car section was not available. My heart sank thinking they are taking. No, no, no. The credit card department in Chase and the car loan department in Chase are completely different. Night and day. They have nothing to do with each other. As long as you make your payment on your car, you'll get the title to your car. Okay. Now, as far as the credit card is concerned, they could call and harass you, turn it over to collections, they could sue you. But no, that's not going to affect your car loan. Now, that would be different if it was a credit union. And I talked about that. If it's a credit union, they have what's called a cross collateralization agreement. And if you owe a credit card to a credit union, that can also be a lien on the car. Okay. But not with a bank. So you don't need to worry about your car. No, Franklin. Well, you were worried and then you solved the question after I explained it to you. Good. So Rick asked, if you have debt in collections and the debt is sold later to another collection, does the statute of limitations start all over again? No. Statute of limitations, it's governed under state law, Rick. And normally the statute of limitations, now this is, a statute of limitations is not to collect a debt, but it's to be the time with which you can file a lawsuit. Technically, a debt collector can try to collect on a debt that's 20 or 30 years old. They just can't legally sue you on the debt. Okay? So statute of limitations has to do with when they can file a lawsuit. And it usually, the time period, and it might be, let's say it's 5 years or 6 years. Usually it's from the time when the debt was incurred or when you last made a payment. Okay? So if the debt is 5 years old and you made a payment, last month, and the statute of limitations for where you live is going to start all over again, normally. But once again, you don't need to worry about it. If you're getting Social Security or pension or disability or VA benefits, 401k, IRA, you're judgment proof. They can sue you. They can't do anything to you. Now, that doesn't mean that we like to be sued. No one wants to do that. You're not going to have to go to court. So that's one reason people enroll in helps is so that we send these letters that makes it less likely that a creditor could decide to sue you. They could still sue you. I used to give a percentage, but I don't do that anymore because I was given a percentage, and some people would have more higher than the percentage sue them, and they were getting upset. Well, Eric said only this and that. No, I don't want to. No, but the bottom line is you don't need to worry. And if you do ever worry, you call us on the phone. Absolute resolutions, investments, original creditor. How can the collector claim to be an original creditor? I don't know if they're an original creditor. Well, they're not an original creditor, obviously, but that doesn't prevent them from still trying to collect a debt. U.S. Bank could either sell the claim to someone like Absolute Resolutions, or they could assign it to them to collect on their behalf. There's any number of ways they would do it. And then some of these collection agencies, they come up with pretty original names to try. Absolute Resolutions Investment. I don't know. Is that supposed to make you feel that there's going to be an absolute resolution to this matter if you get a letter from them? Maybe that's a little intimidating. I don't know. They come up with some pretty clever names. Richard asks, are personal unsecured loan judgments different? No, they're not different. No matter what debt you owe, I'll explain the ones that are different in a second. But the only ones that are different are taxes, okay, really, maybe a student loan, and maybe child support. That's it. Okay. It doesn't matter if you owe debt to, I don't care who it is, but to um, the most important person on earth. They can't collect from you. Okay. Uh, or if it's a payday loan, they can't collect from you. Okay. Or if it's a high interest lender, or if it's a default on a car, or if it's a timeshare. It doesn't matter who it is. They can't collect from you. Okay. It doesn't matter. Okay. Mary says it's a good idea to keep your credit bureau files locked. I don't know if that's necessary to do that. I don't think it helps any. I think if anything, it fouls up your credit. But I don't get into credit things. Like I said, if you want to rebuild your credit and you've been a part of Helps for 90 days, call us or email us, and we'll give you the link to sign up for 7 steps to a 720 credit score with Phil Tyrone. You can rebuild your credit. Your credit is based on your recent credit history. Okay. Hope so. Now, if I've talked to you about your question on the chat and I haven't answered it, or you're having a follow up, don't be scared to ask me. Okay, I'll do it. Absolute resolutions will absolutely not be collecting. That's right. They will absolutely not be collecting. Thank you. Okay. This person contacts us from California. Says my wife passed away in last September, and I'm now receiving letters saying she owes over 7,000. They are possibly trying to lien my home. I'm still mortgaging. I don't know if I'm a client. I've been years. We have so this person was probably an older helps client, and they haven't talked to us for a long time. And now all of a sudden his wife passes away, and he's getting some contact. Okay, he lives in California. So when his wife passed away, it appears that they own the home together with survivorship rights. That means when she passed away, the home automatically was in his name. Okay, and his wife had some credit card debt, and there was probably no estate because when she passed away, all her assets they were owned jointly. They went to him. Is the credit card company going to be able to collect or on? There are 7 states in the United States that are consumer. Um, I'm having a mental block. Um, Community property states where if you own something in your name and you're married, it's the wife is deemed to own it too, or the spouse is deemed to own it too. It's same with debt. If debt is in your name, the spouse is deemed to own it too. But it's simply not the practice of creditors like a credit card company even in a community property state to try to go after the surviving spouse. They simply won't do it. So we're going to tell this guy he doesn't need to worry. Um, and we're going to tell him if he gets a bill for the wife to get a copy of the death certificate, make a copy of it, staple it to the bill, send it back to him, and put down no estate. Okay? How many helps clients are there out there? Tens of thousands. I mean, it's not a secret. There should be millions, and someday I think there will be. Uh, there's like 35 million people AARP or something like that. So, boy, and that's the half of seniors that have money. There's a lot of almost like 42% of seniors have incomes less than 2% of the poverty line. Okay, under some adjusted poverty line figures. And many of those have debt they can't afford, and they're being harassed by creditors. 42 million. And we've got, several tens of thousands of clients and more every day. But someday I expect helps to be really big. The judgment creditors or the collection agencies and the creditors they don't want you to know about us. They don't want you to know that your income is protected. They don't want you to know that you can be protected. You know, the seniors that have money pay their debts. The half that have it, but the seniors that are struggling, that are lower income, they need the money for their household, for their basic needs. And these judgment creditors or these creditors don't want them to know that their Social Security is protected. And so there's almost a concerted effort to keep that information away. That's why, the National Council on Aging, in their articles, they never mention that and they get 50 million years from the United States government, $50 million a year. And in their articles, they never tell a senior, by the way, your income is protected. If you're poor, you don't need to pay this debt. Uh, they don't talk about the fair debt. In fact, what they do is they steer them to debt management companies. So they pay the debt. Uh, I talk about this a lot. Okay. I get upset about it. So, Ms. H says, Eric, I did keep two credit cards I can pay from my bank and one other. That means that shows good standing on my credit report, even though negative from others I could not pay. Yeah, absolutely. You bet. That's going to help you rebuild your credit. I co-signed for a car loan. It got repoed. Can they get my house? No. Okay, I'll explain why. So if the car got repossessed, eventually it's going to get sold. You're going to get a letter in the mail called a notice of deficiency. When one of our clients get that, when they let a car go back, they get that letter to us. We're going to send a letter, a cease and desist letter to the lender, let him know that your income is protected. They'd have to sue you, get a judgment. They can't touch your Social Security. They're not going to be able to. They're not going to take your home. Your home is protected under state exemption laws, but even if you had equity in your home over and above the state exemption for the law, or the exemption amount for the state where you live, it's not their practice to go after your home. And if you owed it with a spouse and the judgment's just against you, if you passed away, then it's going to go to your spouse. No, you're not going to need to worry about that. You can always call and talk to us too. We'll go over that. We do that all the time. Um, you could always envision a scenario where that could happen. But 76, 74, 40, 30 to 40,000 bankruptcies helps for the last 12 years. It doesn't happen. Okay. And for me to try to scare you into thinking this could happen, it would be terribly wrong for me to do that. Yet, unfortunately, there's some attorneys that try to tell people that to drum up business, you've got to always tell people about the odds. It's like walking out on a sunny day and getting hit with a bolt of lightning. It's not going to happen. Is it common for creditors to contact helps for proof of help's income? Uh, it's not uncommon that when people enroll in helps, you know, when you enroll, we enroll you over the phone. We keep you on the line. We'll push a button and you're going to get an email that explains that you're a member of helps and has all our contact information, has links to videos, tells you about our YouTube live that we do here. And then you're going to get a letter from us in a week or so. And one of the forms is you're going to ask you to return what's called a client authorization form, which is you sign that. It gives us you give us authority to talk to your creditors about your debt. And so, sometimes we need that. A creditor will send them a cease and desist letter, and they'll come back and they'll say, okay, we want proof that you have authority to talk to us, to receive this information, to communicate with us about your client's debt. And so we like to send that to them. And sometimes they're going to ask, well, we want proof that they're only getting protected income. So when we send that letter to you after it enrolled, we're going to ask you to give us proof of your Social Security. We don't have to have it, but it's nice if we get it so that we can have it in the file. And if someone asks for it, we've got it there to send to them. We deduct any personal information in there. One reason I think it's a good idea for us to send it to them, is that then they can see that your income and Social Security is protected, and it makes it less likely they could sue. Now, it doesn't matter if they sue anyway, you're protected, but no one likes to get served papers or have the thought of a lawsuit. And so anything we can do to make it less likely for you to be sued, we want to do that. Okay. I'm I'm set up about it too, Monica. I am too. You know, there should be this information should be out there more than it is. Uh, can I forward? Gail asked, "Can I forward letters or emails from creditors via text or yeah?" So when we enroll people, we say we need your creditors. We need it either by uh, email, text, fax, or mail. Okay. In fact, I noticed someone made a comment on one of our videos and asked if they could give it to us over the phone. And I could tell by the way they wrote that, and they said they weren't very computer savvy. And I told them absolutely yes. Just when you call us, tell them that you're, if we get people that are really elderly and not, yeah, we'll take it over the phone. We'd prefer to get it in writing. It makes it easier for us, uh, and I think it makes it easier for you too. But you can take a picture with your phone and send a picture of the debt with your phone. You can email it, text it, fax it, whatever is going to be easier. Okay? So this person contacted us from South Carolina and says, seeking help to settle personal debt and possible recommendations for attorneys in my state that work with this. We don't, I mean, if you're going to call us about settling the debt, we don't do that. And if you want to settle the debt, you can usually do that yourself. But we're going to want to make sure that you understand that you don't necessarily need to settle the debt. If you don't have the money to settle the debt, don't do it. And part of the problem is if you have a lot of debt and you want to settle one or two of them, then, what about the other ones? They could still sue you or they could still come after you and harass you. So a lot of times you don't need to settle any of them and you've got that money available for you, you know, to and there never seems to be enough money no matter who you are, especially for our clients. For our clients, they're going to need the money for their food, for their medicine, and for their needs. Okay. This person contacts us from Florida. My money will run out this year. I'm 80 years old. I have my house for sale. I cannot afford to live in it. It was a flood loss and it's not selling. Am I going to owe any taxes? No, because of the debt. And I've explained why, and we'll tell him why. My ex has not paid back alimony over 3 years ago. 3 years, and the person's out of the picture. They've hidden the money. I need to end what I cannot get and want the life insurance in my name set up in the divorce. You know, we can we can call and give you some direction on where to go. We can't represent you. Now, one of the things I tell this person, if the person owes alimony and they're getting Social Security, contact the district attorney's office. The district attorney can probably garnish up to 60% of their Social Security and give it to you. You won't have to pay attorney fees. This, I have lawyer fees that they're dragging out, which is useless. He's hidden all his assets. Uh, so I would tell if you've got this kind of issues with you can call and talk to us. We won't be able to represent you, but you know before I started helps, I did all kinds of law. I did divorces years ago, so I know a lot of things. I used to do a lot of personal injuries. I did criminal work. I did trials. When I was in law school, I did collections, commercial collections for business. So, and that's where I first learned about debt collection, how it works. So I've been, and then I did 25, 30 years as a bankruptcy attorney. So I know, but I just haven't done one area of law. I've done a lot of different areas. So which has given me help. It's helped me to be able to give people some counsel in different areas. Okay. After U.S. Bank Capital wanted to discover Sue, and they find out I'm in predicted income, would they next place a, a lien on my home? Well, okay, it depends on the count of the state where you live, but normally a judgment against you becomes a lien on property, real property. I'm talking about dirt, a home on dirt. Normally not on a mobile home, although there's a few states with an exception, but not many. In the county where the judgment is located. Doris says, thank you for making sure that we don't worry. Well, I know that. I don't want you to worry. So this person contacts us from California. This is what they say. I'm being sued by a plaintiff, Discover Bank. He said, I wrote a letter explaining how I fell up and ended in a wheelchair and how my only income is SSI. And I don't have any assets, still no living family to help. But they're suing me anyway. And I have been served. Uh, I have a mental disability, anxiety, depression, and physically disabled. And he lists what he has. I've been contacted by Gerstle Law Firm, PC. They're a debt collector law firm. About my debt to Capital One for neither of these debts is enough to get debt consolidation. Well, you don't need to get into debt consolidation. And you not need to worry about this. This is the kind of guy we can help. We're going to tell him you don't need to be depressed or have any anxiety about this debt. They can, you know, he may get our help for free for all I know, but when he gives us his creditors, we're going to send a letter to the attorney that sued him and going to let him know his income's protected. We're going to call him on the phone, let him know why he doesn't need to worry at all, why he's not going to need to go to court. I'm going to tell him don't be depressed or have anxiety about these debts. If you need to be depressed or have anxiety, have it about something else, not this. I don't want you to have it about anything. Obviously, I'm just being cute. But I don't want you don't need to worry about the debt. They can't do anything to you. And if they start to worry tomorrow again about it, you pick up the phone and you call us. Okay? Sometimes I'll tell people that, if you're really struggling with worry, sometimes when I talk to people or we talk to people, they'll understand why they're going to be okay. Okay. But then for whatever reason, the next day or the day after or later, all of a sudden they start worrying about the same thing. Okay. Sometimes I'll tell people when that happens, if you're at night worrying about it, think about when you talked with us and you understood then why you're going to be okay and they couldn't do anything. And realize that, and then concentrate on that, and that should make the worry go away. But if the worry comes back, you can always call us back. Okay? Oh, I wrote someone today from New Jersey. Um, the wife was younger than the husband. Okay, by about a little bit over 10 years. They own the home together with joint tenants with rights of survivorship, and they have a fair amount of equity in the home. Okay, more equity than the exemption for the state is, but they own it together with survivorship rights. She gets Social Security and a pension, has about 20,000 in unsecured debt. Owes a little bit of money to the bank where she banks at, and she'd like to keep that credit card. And I said that's fine, but she had a credit card with Home Depot that she wanted to keep. But Home Depot credit card is backed by Citibank. And Citibank, she owed a lot of money to them, and she was going to put that with us. And I told her, when you put that with us, Home Depot card is backed by Citibank. It's going to likely be cut off too. So she doesn't need to pay Home Depot either. Um, she owns a home with her husband, and no one has a judgment, and she wants to stay in the home. And we discussed that, maybe it might make sense for her to add her daughter's name to the home. She could consider doing that. We sent her some information. She could consider doing that. That way, if she owned the home together with her husband and herself and her daughter, so when the husband dies, the home would be owned by her and her daughter, and when she passes away, the home would be owned by the daughter. There wouldn't be any need for a probate, okay? And if someone had sued her and got a judgment, uh, when she passes away, the judgment lien would go away and the property would automatically transfer to the daughter, as long as the daughter's name was on the property before someone sued her and got a judgment. And she mentioned that she had her dad had put her name on his property, but he lived in a completely different state. And she was worried if they got a judgment against her, they could go after that property. And I explained, well, highly unlikely because a judgment is only a lien on property in the state where you live, and usually only in the county where the judgment's located. And when he passes away, they wouldn't even know about that you own that property. And so the chances of that being an issue is really close to zero, maybe even less than zero. Is there anything that can be done to relieve student loan due to disability? Absolutely. If you're permanently disabled, you can have those debts discharged. We have an email that explains exactly how to do it. Contact us. We'll send you that email. Monica. What if Social Security uh, is directly deposited in a Florida bank but living in another state? Okay, it doesn't matter where the bank account is. The law that protects money in your bank account is a federal law. See, if you have a Florida bank account and that's where Social Security goes, if you got sued and they garnish the bank account in Florida, all the department in the bank that deals with garnishments examines the account. If they can see it came from a federal source, they times that times two, and then they protect that. Okay? Doesn't matter if you live in California, New Jersey, Wyoming, Montana, Oregon, I don't care. Doesn't matter. And all of those that thank me, I appreciate that. And for anyone that's listening the first time, I think you can tell that we help people, and that's what we're here for. If you've got these problems, you don't have to continue with it. You can give us a call. You can look at all our other YouTube videos. We have lots of videos with senior living. Uh, senior living on YouTube. You can type that in, see videos. I do one, almost every other week with them. Just did one on Social Security with them, and we're going to do more. And hopefully, we're going to do YouTube Live with senior living. I want to. Anything we can do to get the word out, because that's what we're trying to do, is get the word out about help. So that's why we ask you to, press the like button, subscribe to our channel. If you do that, then the I guess they call it logarithms on the internet pushes this out to more people so that if a senior doesn't know anything about it, they type in some information, our website's going to pop up. Okay? And this is ours actually flown by. But here's another one. This was I think it was a comment on one of our videos. It may have been yesterday. He says, I heard you mention Truist Bank. I have a Truist account in which my Social Security is deposited in monthly. Can I have my Social Security garnished with Truist Bank? I'm being sued by LVNV Funding in June for an unpaid credit card. Should I change banks? I'm 70 years old. It won't be a problem. I'll explain where Truist Bank could be a problem. But first, the only way Truist Bank would be a problem is if you owed money to Truist Bank. Then, like a credit union, they had you sign a form letting them offset money from your bank account to pay them for a debt. Okay. Normally, banks will not do that, and there's a federal law that tells banks they can't offset money in your account that contains Social Security unless you gave them permission to do that. Okay. Truist Bank is an exception. They have you sign a form that does that. But in this case, it's totally different. This guy says, I bank account at Truist Bank. I don't owe them any money, but I'm being sued by someone else. But I heard you mention Truist Bank. Are they going to protect my funds? The answer is yes, they are. Okay? Okay, here's one more. We almost near the end, but we're on a roll. US Today had just published an article saying seniors who are disabled with student loans will have their Social Security garnished by the government. Is this an exception to the 2012 or 1978 laws you mentioned? And I said, oh, we'll talk about this on YouTube today. Oh, and I waited to the end to talk about it. I'm sorry if you're the one that. Uh, yeah, a student loan can be. They've started garnishing for student loans. It's not going to happen overnight. It may not happen to everyone, but it may. They're going to ramp it up again. They can offset 15% of your Social Security to pay a past due student loan if you make over an amount about 750 in Social Security. Uh, but they got to send you intent to do that, and they give you 60 days before they're going to do that. But for a lot of our clients, that gives you time to get on income-based repayment plan where you're not going to have to pay anything. If your only income is Social Security and you owe student loans, it's highly unlikely you would ever have to pay that student loan. You can get on an income-based repayment plan and not have to pay it. The only problem is there's paperwork involved, and it's complicated. We used to help people do that when helps was new, but we got tired of waiting on the phone for an hour and a half to 2 hours for Social Security for the student loan people to pick up the phone. So we tell people how to do it. So if you have this problem, we can send you emails on how to do it. It's not going to happen overnight. I'll be interested to read this article in US Today. It's maybe scaring people when they don't need to be scared. Okay? And maybe I'll try to talk about this again tomorrow since I waited to the end to talk about it and this guy asked about it. Okay. So it's been an hour. I want to thank you for participating. I had a lot of good questions today. Um, Please press the like button, subscribe to our channel. I'll be anxious. We've got, we're close to 18,000. I would love it when we get 100,000 people on our channel. I need to get more dynamic or more involved to work up to get the juices going so more people subscribe. Because I know there's a ton of seniors that have these problems that don't know anything about it, and they would love to hear about it. So I need your help to share this with others. I want to thank you all and for your kindness and God bless you. And I'll see you tomorrow at the same time.